Okay, so while folks are coming in, we'll go ahead and get started. Good afternoon. Thank you again for joining us on the COVID-19 Global Disruption Update. So many things are changing and happening on a daily basis, as we all know. Keeping up with it is certainly challenging, so it's great to have good partners and people you can connect with. So once again, just sharing our date for this recording will be 4/9/2020, in case things have changed again and you're reviewing this recording at a later date. Again, speaking of recording, we are recording the webinar, and so if you do not want to participate in a recorded session, then please exit the recording at this time. And I'd like to take a moment just to share that, again, we are not your attorney or tax accountants for your organizations, and as such, none of the information we are sharing should be construed as legal or financial advice. Again, we always encourage you to consult with your business partners for that guidance for your own organizations. Okay. So on the phone from our team today, we have myself, Amanda Erickson, and Jeannie Valier from HRx Services. Jeannie, you want to take a quick moment and say hello to the group?
Good afternoon, everyone. I am super excited. We have another guest panelist.
Thank you, Jeannie. And we are joined then by Kait Feeney. Is that correct, Kait? Did I pronounce it correctly?
You did. That's me.
Great. From Tilt. Want to go ahead and introduce yourself for a moment?
Yeah, absolutely. Hi, everybody. I just have to say a big thank you to Amanda and Jeannie for having me here today. I'm really fortunate to know them and consider them resources. My own network, as Amanda mentioned, I'm currently the COO of a Fort Collins-based tech company by the name of Tilt, and that stands for Talent in Leave Technology. As you might guess, we help companies manage leave of absences. The easiest way to think about what we do is in the lens of automation plus human experts. So we provide guided leave plans to HR, their employee going on leave, and that employee's manager. And then we also connect them with our own internal Tilt guide, so a real human who can reply in real time to all of the questions and things that come up along the way. One other thing I did want to mention too is I am a labor and employment attorney by trade. I have previous experience in-house with another startup here in town where I was the general counsel and then their head of HR. And then I went into private practice at a boutique firm and then a very large national law firm. So hopefully I can bring some experience from all of the different positions I've had to the table today. But the last thing I'll just reiterate is me being on the webinar doesn't create an attorney-client relationship between us. So hopefully you have really good lawyers that you can connect with on that. But yeah, happy to be here today. So thanks so much for having me.
Oh, thank you, Kait. We're really excited. I'm looking forward to this conversation. I think it's going to be interesting and appreciate your time. And before we go further, I also want to say we are joined today by our colleague, Mike Kohler with Elevate Virtual. And Mike, would you like to take a moment to introduce yourself?
Do you think I'd ever decline the opportunity? For those who don't know me, but I see a lot of familiar faces and names, I'm Mike Kohler. I'm the Elevate Training Coordinator. Elevate is a program of the Larimer County Economic and Workforce Development Department that typically, well, in the past has offered in-person training workshops by some of the top experts on the Front Range, including HRx Services. But amid the crisis, we've converted the whole program to virtual format. So I thank you for attending. I, like Jeannie, am excited about Kait joining us today because I am familiar with Tilt and the great program that they've put together. It's definitely worth exploring because it converts leave management instead of a dread factor that hey, it's something you can manage together with the people who are taking leave. I'm slightly jealous of Kait, however, because Jeannie expressed how excited she was, and Kait, I used to get that excitement. Welcome aboard.
Thank you, Mike. And always, we just want to say thank you for the opportunity to connect and do this as well. We appreciate that. So in our session today, we'll be working through facilitation of this program a little differently. We're including some stock questions that we receive kind of on a consistent basis, as well as questions that we received on Tuesday of this week. So if you were able to participate in our meeting earlier this week, thank you. We love to see that, because any kind of questions that you provide us, we really do want to be able to address. We're glad to see you here again. If you weren't able to participate, the recorded webinar is found on our YouTube channel, which is HR Explained, and also something that we can provide from our website if you want to hit that as well. Well, let's go ahead and get started. So as always, let's do a little housekeeping. Tools box. Okay, once again, this may be hidden down at the bottom of your screen, but let's see if everybody's finding and tracking well so that we can make sure you can ask the questions when you need to. How many of you joined us on Tuesday of this week for our first session or have been on one of our other sessions? Go ahead and raise your hand now and find that tool function. We'll give it a minute. Okay, awesome. Thank you. So it looks like, ladies, we're about a third of our participants today have done that. So that's good for us. We're going to have some good content to be able to share, and information that we've kind of talked about maybe in previous sessions will also be included in this today. All right, there's also a chat bot feature, which is similar to any other chat feature in a webinar. So please, you're welcome to use that. The team and I will do our best to moderate this area, but I want to direct you really to that question and answer box. And there's a couple of reasons why. So using this box will allow us to engage there a little easier. If we get multiple questions that are kind of similar in nature, it raises and rises to the top. So that's nice. And it also allows us to pull a report with these questions at the end. And when we can do that, then we can incorporate that into our further sessions over the next coming weeks. So I want to do a short plug just to, again, remind you that we are doing these sessions on Tuesday as more of a content-based session, just talking about updates and what's going on. And then Thursday, we have a guest panelist like Kait who are going to come and speak with us about something specific. So without further delay, let's go ahead and begin. So question number one, what would be the reasons that people would need to take leave? Kait, would you like to start?
Yeah, absolutely. So just generally speaking, in your business, there's many reasons employees would need to take a leave. And some of those obviously can be expected from PTO and vacations. I know we're probably all missing those, to doctor appointments and, school functions of your children, et cetera, voting. And then there's unexpected reasons, if there's an illness or a death in the family or jury duty or something like that. But obviously, the reasons in COVID world land are a little bit different. So I don't know if I'm getting ahead of myself.
No, I think that's
the next question. Or
yeah. No, we will. We'll definitely talk about that. I think that you're exactly right. Like the reason for leave and what employers call it, vacation versus PTO versus sick time, and what would be applicable to different size employers would also be a factor there. But the need to take a leave, I think, is certainly something that exists for a lot of organizations. I would say that some of it is then also regulated and legislated so that they need to be able to provide that leave. But I also think that there are some employers who are impacted, obviously, now with COVID, to your point, that maybe haven't had to deal with that in the past. Jeannie, anything to add to that space?
Just a little bit. In addition to that, I think employers who didn't previously know outside of the traditional leave, vacation, sick time, things like that, specifically like FMLA. I mean, if they hadn't been having to adhere to it, that wasn't something they were familiar with, whether it be the paperwork process, the engagement, the interactive, all of that. And now all of a sudden, employers of 500 or less are now a portion of that carved out as it may be, are exposed to it and have to adhere to it. So they got to get real quick knowledge and very fast.
I agree. And to that point, let's talk then kind of about that next question. So now employers that are maybe not familiar with leave requirements or the requirements to provide leave of some sort, and even employers who maybe were familiar with it, that were, an FMLA covered employer, for example, may now need to deal with that aspect. And especially because FMLA traditionally doesn't have to be paid, but now we're in this aspect where we do need to provide paid leave. Can you review what leave could be impacting employers now? So Kait, let's start with you, since you were kind of diving into the COVID piece a little bit, and maybe just high level, since we have some people who weren't on our Tuesday session, kind of share a little about that.
Totally, absolutely, happy to. So just generally speaking, before I get a little more nitty gritty, some of the reasons now that your employees might need to be taking leave could be due to their children's school closures, childcare provider unavailability, or health reasons, whether it's their own or someone else that they know due to COVID-19, and either they're caregiving for that person or themselves, or there's a social distancing order in place. So just really high level, those are the general reasons. What the law that was recently passed is the Families First Coronavirus Response Act, so FFCRA. I remember that's the acronym for it. But anyways, so that went into effect on April 1st. And really what this law does is it mandates who have 500 employees or less an expansion to the traditional family and medical leave, and then also paid sick leave. And so I'll kind of unpack first this expanded FMLA coverage, and then I'll talk about the paid sick leave, and I'll have Amanda and Jeannie plug in at the end in case there's anything that I missed on that. But so as I mentioned, this expanded coverage and eligibility for emergency FMLA has to do with an employee who's unable to work or unable to telework, work from home, because of their child's school being closed or the unavailability of their child's care provider. And interesting thing, although I'm a mom, so I feel I can say this, the child in this sense only applies if they're under 18, although, we think of our children as forever in the legal sense. It's under 18, so I just want that to be known. So the employee in this sense, if they're going to be taking the EFMLA, they must have been employed for at least 30 calendar days. So that's a different eligibility requirement than the traditional FMLA. And then the other piece of this that's really interesting is there's a paid component to it. So in traditional FMLA, as we all should probably know, that's unpaid. But in this situation, the first 10 days of EFMLA, they can take up to 12 weeks. I should have said that. The first 10 days would be potentially unpaid. And then after that, you would actually have to pay your employee. And so there's certain requirements there for the rate of pay, if they're full-time versus part-time, et cetera. But again, this is just applying, this EFMLA is only applying to child school and the child care. So I think of it, one way to think of it is it's essentially adding like a sixth reason to take FMLA, but this piece of it, like I said, is paid. So that's different. And then the other things for it is, again, this applies to employers with 500 employees or less. Something interesting when you're considering, okay, does this apply to me? Do I have 500? You would actually calculate that at the time that the employee is requesting the leave. So I think that's important because, some smaller businesses are being faced right now, with layoffs and cuts and furloughs and things like that. So if you are I guess where I was going, that's 500 or fewer. So as long as you have that, you're still going to be subject to it regardless of the employee population. So do you know what I mean? To confuse anybody there. But so keep in mind, even if you're laying people off, as long as you're under that 500 bucket, this law still applies to you. Now there are, do you want me to stop right there? Is there anything you want to clarify?
No, not at all. I thought that was really good. So, and I'm going to throw up just a slide for the purposes of what we're talking about so that people can kind of see how that works through. And everything that you just said, I thought was fantastic. And again, just to kind of highlight, because I know having that visual can be helpful, that the FMLA, the expanded FMLA, really is only applicable if you're looking at needing to take leave because of that child care situation. So there's a separate component to it that I know Kait was about to talk about just here in a minute. But that paid sick leave provision is more for someone is actually ill and the child care component is still there, but this one is more for kind of that front end piece. So to Kait's point, if you don't have, there's 12 weeks of leave, that first 2-week period or 10 days essentially is going to be unpaid, right? And that is why they've established then that you also have this opportunity. And I'm going to go back one slide here just to kind of, again, illustrate that paid sick leave point, that the paid sick leave is designed to be helpful to supplement kind of that beginning piece. And that is that 80 hours that you could initially take. So if you were in that situation where you had a minor in the house under 18 without childcare or school or anything going on in that space and you aren't able to work or telework, then that would be the circumstance that this would apply. So again, just highlighting that both kind of work together. And that's the only thing that I would add on that end. Jeannie?
So I actually had a question come in and it kind of segues well with this.
Sure.
So the example being an employee who exhausted their 80 hours of paid sick leave under the paid sick leave portion of the FFCRA. And what happens if they're still ill beyond that? Now, is that considered a serious health condition that would traditionally then potentially fall back under FMLA?
I'm not sure if I was completely following. Did this come in the Q&A? I was trying to pull it up there.
It is, and I'm trying to kind of frame it. So basically, the original question was, if an employee is considered high risk when it comes to COVID-19 because they are on a certain medication, and then they've exhausted their 80 hours of provided paid sick leave, and they've used any prior vacation, is the company expected to offer them additional time? So I guess that's kind of where I was leading with that question. Would that additional time or job protection then fall under the traditional FMLA?
Interesting. Yeah. So I think it would honestly depend on the circumstances a bit. And so one of the things to keep in mind is they could potentially, if they've just used this paid sick leave for it. And actually, I think, let me actually go through that paid sick leave quickly, and then we can talk about kind of like the interplay. I think that'd be more helpful for my mind too before I answer that. So as you were saying, so we have FFCRA, and so we have two rules that basically came out of this, and that's the expanded or emergency FMLA, which I just went over, and then it's also this paid sick leave component that we have. And so Amanda alluded to it a little bit already, but for the paid sick leave, there's actually 6 reasons why an employee would be eligible for this. And this is just, 2 weeks that they're getting, that 80 hours, as she mentioned, but this could be if, they themselves are on a quarantine, if a doctor advised them to self-quarantine, if they're experiencing certain symptoms related to quarantine. And then obviously there also is if they're caring for a child during, that school closure. And then there was another one in there that we haven't got a ton of guidance on. It's basically a catch-all that was built in. And the Secretary of Health and Human Services could essentially come up with something else as we see as this plays out. With the paid sick leave, all employees are eligible regardless of their length of employment. So that's a little bit different than the emergency FMLA. You have to have worked for the 30 days there. It's just the 1 day for the paid sick leave. As Amanda mentioned, you could use potentially that paid sick leave for the first 10 days of emergency FMLA so that there wouldn't be that gap in income. And so then the two could run concurrently and then be paid. So I think now if I go back to your question, and apologies, but I'm going to ask you to repeat it one more time.
Sure.
Screen, but
so basically using that example that we got, an employee utilized they themselves are potentially, they're the person that's sick, so they've used their 80 hours of paid sick leave. They've exhausted any prior company provided leave benefits that we kind of talked about in the beginning, vacation, PTO, things like that. Now the question is the company expected to offer them any additional time, whether it be paid or unpaid? So that's where I segued into, would that fall under FMLA? Is that considered a serious health condition?
Right. Okay, great. And I think then originally where I was going with this, where my mind went, and Amanda, please chime in if you think otherwise, is it truly does depend. If they're seeking care still and a doctor says, this rises to the level of a serious health condition, be it because of the fear that they're experiencing to it or any other, maybe some type of like secondary, symptom or something like that, then potentially they would. But keep in mind, they still only have under FMLA the 12 total weeks. So this emergency FMLA is not in addition to that. So if they've already used FMLA for another qualifying reason during whatever the 12-month period that employer is using, they would only be able to use the remaining for that. And even then, I still think it's sticky. I don't think it's black or white. I don't think that it would automatically, they would be entitled to that. And I think more from a practical perspective, not a legal perspective, I think the answer that I would say there is definitely just talk to them, especially with everything that we're dealing with right now. I think the best thing anyone can do, whether you're on the employer side of this or you're the employee, is just engage in a human conversation with, your boss or your manager or your employee if you're the boss or manager. And really, that you'll be able to, through hopefully those types of conversations, sort of discern, okay, do we have a policy in place already that maybe they will be eligible for something that's paid, or is there some type of reason or something we could do to just put them on an unpaid leave, or could we get creative and flexible about it and maybe they just alter their work schedule to make it work. So I don't know if that completely answers it, but those are my general thoughts, I think, on the question.
I think you did a great job, and I'm going to kind of continue to tag on that, because I think that the struggle employers might face is, even if they wanted to engage in the process, first and foremost, were they a covered employer under regular FMLA? So making that assumption, let's say they were. I think the next challenge is, the whole terminology for continuing treatment or the 3-day incapacity, that's going to be challenging considering doctors don't want to see you. And so doing these virtual televisits or, them just saying stay at home and let it run its course. The normal employer says, hey, we have to engage in the interactive process. You have to follow these steps. So to your point, Kait, I think it's super critical. Now is the time for a little flexibility. I know Amanda and I always say, or at least between the two of us, we always say, I think the DOL wrote these laws to ultimately for the betterment of the employee. Therefore, why not go ahead and err on the side of let's show some grace, let's show some kindness, and yeah, they can't maybe get to the healthcare provider twice this month or whatever documentation, but to your point, can we do a leave of absence? Can they work in the evenings versus the day? Can they telework every other day? Can it be intermittent versus, something else?
Correct. And I think just kind of jumping in, and I've put up this other slide here, kind of just talking really high level about FMLA, because if you're an employer right now, you know, the interesting piece of the expanded FMLA provision is really that it is just focused on that healthcare, or I mean, the child care piece, right? So if you're looking at expanded FMLA, this is, I have 500 employees or less, and my employee has the regular hours to work, because that's the other component of FFCRA, is that this isn't, you know, there are some strict qualifications regarding whether or not this is considered COVID related need. And for leave. And in my opinion, I think the biggest thing that they're saying needs to be addressed or needs to be qualified is whether or not the employee would still have the opportunity to work regular work hours. So if the employer has reduced hours, reduced schedule, there's you know, some change in how that's working because of business slowdown, they've made it pretty clear in the questions and answers that that no longer really qualifies as a COVID related need. So when we're talking about this, you know, applying this versus what is actually happening in the business, to that point, having that communication piece back and forth with the employee and seeing if there's a way to be flexible is probably the best solution for everyone. And to what Jeannie was saying is, if it runs from expanded FMLA into regular FMLA, or paid sick leave because I have COVID related symptoms and I was also regularly scheduled in my workplace, all of those things align, then the component becomes, okay, well, are you an FMLA covered employer? So FMLA covered employers have 50 employees or more, which is interesting because FFCRA would maybe apply to a group of employers who have 10 employees or 5 or 20, and then that would not apply afterward. Plus there's that paid versus unpaid component, at least that's legislated. So I think that it's an interesting dynamic. I definitely don't think this is the right answer. I think we've been given some further understanding around, you can't take them one at a time, like 12 weeks here and then 12 weeks there, that there is more of this combined piece like you were talking about, Kait. So I think that there's more still to come, and we're certainly going to see it. But to Jeannie's point, and maybe that conservative approach, if not for anything else, is really to engage the employees in that process and try to make sure that you find a workable solution if you can. So I think that's good. Did you want to add something as well, Kait?
I just had one other thought that kind of came to my mind that I wanted to call out for, employers on the phone or on the call, is that keep in mind too, these new provisions that we're talking about under the FFCRA, they were effective as of April 1st, but they sunset December 31st. So I know right now it's still too early to know where this is going to go or how long, we're going to all be working from home and everything else, but there is an end in sight to it. This isn't something indefinitely that now you are going to be subject to. And when it comes to the paid sick leave portion of that doesn't carry over to the following year or anything. And it also is another important note that I wanted to mention is that's in addition to any sick leave that you already offer at your company. So keep in mind if you are, subject to this as of right now, it's not replacing or you're not complying with it just because you already offer sick leave. It's two totally different things.
Agreed. Great point. Let's talk then a little bit about some of these compliance components, since we've touched on kind of the paid sick leave versus the expanded FMLA versus regular FMLA and how that might all come together. So we had some question around, does expanded FMLA HR is the required paperwork to get employees similar to regular FMLA? And I think we've kind of touched on it a little bit, but maybe we can expand specifically into that. And I'm going to say first, Kait, would you mind kind of sharing, and Jeannie, either one, what would be normally qualified? Like, what would you normally need to do if you were an FMLA covered employer? What are those specific requirements? And then you can answer whether or not expanded kind of adopted that or not.
Totally. So just in general, one of the biggest things with the FMLA that employers should be aware of is that there's no magic words that an employee has to say. They don't actually need to request the leave. How the regulations are written is the burden is on the employer. When you become aware of a situation that is an FMLA qualifying reason, and so, traditionally just what those look like are, a parental leave, obviously after the birth of a child, also adoption or foster care. And then, if you have your own serious health condition or you're taking care of someone who has it, and then there's, some interesting military rules and things like that. So if you as the employer become aware that there's a situation that the employee, meets the eligibility requirements, they've worked for your, workforce for the requisite amount of time and the 1,250 hours and within that 75-mile radius, then it's on you as the employer to actually issue what's called a notice of rights and responsibilities to that employee, so that they're aware of what it is they need to do. And you have a certain amount of time within 5 days, I think it is, to provide that. And then there's some other documentation depending on what the reason for the leave is. You have to provide in writing for them if they're approved, or denied, and then why as well. And then there's some medical certifications, traditionally speaking, that you can ask an employee for. One of the biggest changes when we're talking about the expansion under the FFCRA is that they don't, this is really to protect the healthcare system so that it doesn't get overwhelmed. And there's been some varying guidance out there on it, but I know that the CDC was one that says, you shouldn't ask them to verify, from their medical provider what the reason was for. And that's because they don't want to inundate with all these requests because they have people who are trying to be seen right now, for different reasons. But the IRS did issue some guidance on the types of things. And if anyone's looking for a template, I'd be happy to provide. We created one at Tilt, and being that it's still so new, I don't know if I'll remember all the things. So correct me if I missed something, but there's certain written documentation that you can ask, and that's, you can get their employee name, you can have them certify the reason why they need this. If it's for a school closure, you can ask for supporting documentation, such as it could be the email that came from the school that they're closed or something. But you're not actually, in this moment in time, supposed to be certifying with, a positive test or something like that, is how I understand it at the moment.
That's actually right.
Jeannie,
question number 44 in the IRS Q&A answers that. I actually put that in the little chat feature. So you hit all four of them perfectly.
That's awesome. That's awesome. Well, and I think that you're exactly right. When you're talking about the certification required for FMLA leave, and if you're a covered employer, that means you have that 50 employees within a 75-mile radius. So if you have multiple locations, that's kind of what you're looking to determine that medical certification process and the notification process is very, very detailed and specific, and requires a lot of kind of general information that this is not, essentially, right? We're seeing that there's a lot more flexibility, and a lot of that has to do with the fact that you can't really be seen easily, and to your point, they don't want to inundate the medical system with trying to get a lot of this kind of covered. So once again, I think we just circle back to communication is key, and that's the king right now, right? Is making sure that we're staying in touch. And while there may not be guidance, and I know we're going to touch on this in a further question, there may not be guidance that it's the employer's duty to understand that this is an FMLA request. It is certainly something that we think is probably best practice. And I think that that's coming up. So we'll kind of talk about that here in a minute. I'm going to go ahead and go to our next question and say, do you need to provide, and I know that we've all dealt with some kind of version of this question, but let's kind of dive in a little bit. do you need to provide FMLA leave or EFMLA leave due to COVID-19 fears from employees? So I'm concerned about being out in the public. I may not be experiencing symptoms. I may not be taking care of someone. I may not have a child-related issue, but we have certainly the stay-at-home issues or orders being issued from the governor. What does that look like? I think that adds an interesting element to this, and just kind of want to talk about that. And I'm going to actually, Jeannie, do you want to start on this one?
Actually, I'm going to defer to Kait on this one.
Okay, perfect.
No worries. So I think, the short answer here at first would be no. The FFCRA in and of itself doesn't apply to just a fear of infection. Now, that being said, I would say that the ultimate answer is it depends, because it is possible that a genuine COVID fear may trigger another type of, mental health condition, or something that a doctor might say amounts to a serious health condition. And then in that case, traditional FMLA, may apply to that. And it also could be something that the ADA could potentially be triggered. Do you have to start thinking about this as a reasonable accommodation situation, and what can you do? And, I think in both of those cases, if your employee wants to stay home due to the threat of coronavirus exposure, I think, you should consider letting them work from home if at all, possible, where they're already being forced, all of us, to be home right now, or, allowing them to use PTO if they have that available, or some other type of paid or unpaid leave. I think it goes back to just engaging in that dialogue and having an honest conversation with them, about what really is, where are they at, and just kind of seeing that. Now, the one thing I do want to mention with that is, as much as we are obviously encouraging you to have these types of conversations with your employees, just from a legal lens, you do want to think about that, uniformly, you should be applying the same standards to how you treat those scenarios, not just letting employee A stay home because, you really like them and they've been employed with you for many, many years, and they do a great job, and so they're going to get to stay home because they're scared, versus, employee B over here, who you're like, hey, you just in your mind came on board and got to put your time in. Like, you don't want to get yourself in any type of discrimination situation where you're applying different standards to different employees. But I think, I guess, to sum what I had said is, no, in and of itself, the fear alone is not a reason that these new employer obligations would apply. But I still think there's potentially other ways that you don't want to ignore, and look at what your obligations are for that, and what you have to do. And ultimately, again, it's a tough business decision that you're going to have to make, balancing against, the needs of your business right now, and also the employee.
I think that's a great point. And I know that we've run into questions around that as well. And I love your idea about that interactive process, and that really what we're trying to do is engage in how we make sure that we really consider what our employees are saying and measure that against the needs of the business. And certainly, at least when we've walked through it with people who've had those types of questions, we were really able to identify kind of a workaround. And does that mean that, you might have to get in touch with other partners and other vendors and adjust some of how your plans operate and how some things may be working, or your insurance standards, or whatever that looks like? We certainly know that might be worth the effort at the beginning to at least try to see if we can do a reasonable accommodation and allow employees to, for example, if they normally are working in a position where they're working alongside someone and the confines are, really close together, that 6 feet, can we have people arrive at the same destination in different vehicles, for example, right? Where normally that might be the situation is we're working together and that's how we did it. But today we have to do it just a little bit differently. So the work can still be done. People still feel really comfortable and covered and considered when they're doing the work. And at the same point, we're trying to stop the spread of what's going on right now anyway. Great point. Yeah, go ahead, Jeannie.
I would also kind of just add in there, taking this from a very different standpoint, both of you have come from an amazing place of equity and accommodation. I do know, I think some of the folks that we've talked to, some of the employers are challenged with, we have a lot of clients who have critical essential employees. And how do you manage the importance of maintaining a healthy business, that you don't go out of business, but B, that you're still meeting the needs of their customers, and C, protecting your employees. And I think it's a next step beyond everything the two of you have just said, that you can still do all of it. You can still be that critical function. You can still be an essential employee. You can still look out for the welfare of your employees and make money. I mean, I think you just got to open your mind to all the possibilities.
Absolutely. And that really kind of ties really well into kind of our next question.
Really?
So let's go there. So our next question really talks about, how should employers and employees then be working through notifications? So we've touched on it, Kait, where we talked about, that it was kind of on the employer. Well, it's not kind of, it is on the employer to recognize an FMLA related request for leave, even if the employee doesn't know that's what they're doing. It's a little gray here, right? We're not quite sure how that all works together. So let's talk about that and say, I think ultimately there's a theme coming out of our conversation today, but what would you say? What would you say in that space? Like, what should be the process?
Yeah, totally. I think before I answer that, just backing up in general as we're having this conversation, if you haven't already thought about putting, some type of, communication policy in place, and what I mean by that is just talking to your workforce about, what different technologies are you using to communicate with them for, is it just solely over email? Are you going to be able to implement things now if you have a fully remote workforce, like technologies like Slack and other things? But really the main theme is just that you are communicating and that you are still able to maintain your operations the best that you can. And knowing that while it may be a little bit uncomfortable, I think we're all getting used to these virtual Zoom meetings and things like that. There are things that we're just going to have to do as humans to adapt to this. So just kind of keeping that in mind, I can don't mean this to be a shameless plug, but one of the things we do at Tilt is we're managing COVID leaves through our platform. And, so kind of what that looks like, and this is what you could still do even without Tilt as the employer, is when you, become known that you may have this situation that someone is eligible for leave based on these COVID related reasons, it's really engaging in that conversation. But also, even if some of this is done over the phone, it's having some type of written record for that. And a reason why this is really important too is because while I am definitely not a tax attorney and not fully versed in all of the payroll credits that you get,
right.
The leaves that we're talking about that are, that the employer is paying, is you are in a way getting reimbursed for that through these different credits. And part of that is, the IRS needs to see the documentation showing that these were valid reasons that the employee took that leave. So some of the things would be the template that we mentioned. And so in that, it's a really simple form. It has the employee name. They're, certifying essentially themselves, like why they are taking that leave. And, generally what the reason is related to that. Is it a school closure? Is it they're taking care of a family member? And one other thing that we hadn't mentioned that now I'm thinking of as I'm talking through this out loud is the definition of family member is a little different, obviously, for this new situation. So it's not just limited to that child, and spouse situation. It could, be your elderly parent that you're taking care of, or something. And it's someone that really, I think, resides in the
That's
home.
what they said. Yeah, that's what they've clarified that, because the order itself, or the language itself in the act is any individual. And so that could be a lot of people. And so they have clarified that, I think, in their questions and answers, which is where people are finding a lot of clarity sometimes. But in those clarifications, it does say that normally resides in that home. So you're exactly right? That does not mean that has to be a biological related spouse kind of situation. It needs to be somebody who normally resides in that home with you.
Right, absolutely. And so I would say even, if you're having, verbal conversations, whether it's over the phone or a Zoom meeting or something like that, it's still always a good idea, to follow up via an email and, per our conversation just now, so that you are documenting it. So I think the communication piece of, staying connected and having the right conversations and not just assuming anything and making sure you're, asking the things you should ask and things you shouldn't is a really important piece of this. But then the documentation piece of having that written record, whatever that looks like, whether it's an email or you are going to use some type of template form, to document actually what has happened. So whether it's to provide for, the IRS leader for the credit, or, in the case that there would be, an interference claim or something like that along the lines, that you have that piece. In private practice, what I will say, and I dealt with a few FMLA interference claims in my day, is where it went sideways for employers is when they weren't maintaining the proper paperwork. And in that case, courts are very sympathetic to employees then, and it becomes a he said, she said game, which is never kind of a route you want to go. So
it is not. And even addressing that one step further, some of the clarity points that we've been talking about is there is, because these question and answers are not just for employers, they're for people who are experiencing the need for this leave. And the guidance is very clear right now. It's saying basically there's a 3-step approach. So if somebody has a concern with their employee or as an employee and saying, my employer is not allowing me to take leave and they should be. First step that they are suggesting, and they as being the government, and they're saying, connect with your employer and find out, have that conversation, see if you can resolve it that way. But step number 2, or not necessarily even, you could go directly to number 2, who would be go ahead and call the wage and hour division and let them know that this is happening. And then it says even step number 3, and I'm kind of creating these steps, but there still is not really a step that it's saying. It says you can even bypass all of that and you can directly sue your employer. So when I look at that, I think, ooh, well, I don't think anybody wants that. And I really don't feel like we're trying to do that. This is just the kind of, making sure that we have all the solutions in front of someone so they know what they could do. So I think even though it's not stated that employers should have that conversation, if you're hearing the dynamic from your employee that they're having a hard time with childcare or that something is happening, I think that we're saying, take the advocacy approach and really start to go and engage with that employee and see what you can do. Have those conversations now, because that will be so much better, I think, than any alternative in the long run. Would you agree?
I think that totally. I think that in and of itself, just the equity piece of that aside, is actually a great just risk mitigation tool as an employer to have. When, I was defending employers in management and private practice, and we'd get through a really tough lawsuit, the question often from every manager or CEO that I ever dealt with, at the end of this was like, how can I avoid this in the future? And it usually came down to the fact of like, well, if you just would have asked, these questions at the beginning, or you just would have had that conversation, the employee wouldn't have gotten mad enough or been in this situation where suddenly, they are wanting to sue to obviously fix it or feel like they're getting their sense of justice. So I know that can maybe sound like a hard thing as employers right now. It's a scary time still, and everybody's, stretched thin and trying to figure out what this new normal is and stuff like that. But I think now more than ever, just as a risk management for your own business, it is in your best interest to have those conversations, no matter, how hard they are.
I agree. Jeannie, anything to add, or is there anything that we haven't quite addressed yet in the question and answers? I want to throw it back to you.
I appreciate it. I think, we've got a couple questions out there, and actually we've got several out there, and I've been chatting some responses, mostly referring folks back to the DOL. They have an amazing Q&A, as does the IRS. Surprisingly, it was very informative. So, please, I don't know how well the copy and paste feature comes out of there, but please do so. We will try, if we don't get to all the questions, we will try to answer them. I have to say a couple questions that have come through really at the end of the day, I would highly encourage perhaps maybe you to reach out to legal counsel. Some of them are very employee or employer specific based on a very unusual circumstances. So that being said, we may or may not be able to get to them or even advise on them.
Thank you, Jeannie, and I appreciate that. I recognize that this is a hard area in general, both for a lot of reasons. I think that Tilt and, well, I'm going to say Tilt does a really nice job of really understanding, there's the dynamic of the compliance piece and making sure that you're taking care of managing risk and doing all of those things, right? And certainly that's something that we're concerned with. But I think what your company and that platform really focuses on is this idea that there's a greater purpose to this, which is, people are needing leave for various reasons and having that engaging conversation. I know that's what your platform does. So I think that is the direction that we're really trying to focus on. But when you have specific questions, definitely consulting with your legal team would be really important. So thank you for taking a moment and sharing that, Jeannie. Let's go to then I think we have a couple of other questions at least that we had come through. So the first one is, if my company is over 500 employees, we do not need to post FFCRA posters, correct?
Yes, that's our understanding. That's correct. It only applies if you have 500 or fewer employees. Again, though, given the climate we're in, we'll just note that today you might not be subject to that, but with layoffs and other things that are happening, just know you could in the future. So keeping it in the population count is good, but you wouldn't right now need to post that if you are above that 500 threshold.
Thank you for clarifying that. I think that's actually a really important distinction and probably applicable for some employers who may not think that they fall into that at this point, but could. Very good. Jeannie, anything to add?
I was just actually going to kind of say the same thing, but then I actually had a question that kind of came behind it. So somebody said, we are a covered employer, but we have opted out or we are claiming the exemption. Do we still need to post the poster?
Because they have under 50 employees and are claiming
Correct.
that exemption. Actually, this is a great question. And truly, Kate, honestly, I'm going to tell you that Jeannie and I have also gone back and forth on this because, and are thinking, you're a covered employer. They're saying 500 employees or less. I can make an argument both directions. On the other side, saying if you're taking the exemption, does that now does that disqualify you as being a covered employer? And I think that there's some good guidance on how you can claim for the exemption now, or the things that you need to take into consideration. But personally, I would just be super nervous about not posting something just because I think I'm exempt and potentially down the road someone else would say I was not.
I would agree.
What are you what are you thinking? Like, how do you think about that?
Yeah, no, absolutely. I am aligned with both of you in that process, that I think it is better as a best practice to post the notice. And so then employees are on notice of it. And, if in fact you are subject to this, you are complying with that requirement that the government is saying, hey, this is what you need to tell employees. And instead, if it comes that you're not because you do qualify for this exemption or whatever else, you can kind of cross that bridge when you come to it and have that conversation and say, hey, actually, this is why. We're not subject to that, but I think it would be better to post it and then explain why you're not subject to it rather than not post it. And when in fact you are subject to it, because there are fines and other things for that. And I just think that would be silly, I guess, not to and set yourself up for that.
No, and I think, go ahead, Jeannie.
Oh, I'm sorry. I think doesn't it kind of also, Kate, tag into the same traditional thought process for an FMLA employer who, let's say they have 100 employees, but in their one single location, they do not have 50. So I felt it's always just a best practice still to explain what FMLA is. And when that employee comes and says, hey, I want that FMLA, you say, hey, we don't meet the covered employer qualifications.
Right.
Absolutely. That's the same rationale.
Right. Thinking about that. And just to back up, I can 100% understand where employers are coming from, where they're like, but do we really want to start, that fire? Do we want to fan that flame if we're already saying, hey, we're not going to be considered a covered employer? And I think that to that point, yes, but probably employees, spouses, or significant others, or other people down the road are going to be, also engaged in it, and they're going to know what's going on, and they're going to be familiar with it. So they're going to still get educated in some way. Even if they go to the DOL website, they're going to see these questions and answers. So I think that there's an argument to say that it doesn't matter if you're telling them, someone is. So okay, so I know that we're running up really close to the end of our time. I just want to say we only had one more question, so maybe we can dial into that really quickly. And then to Jeannie's point, any questions that we feel comfortable that we can still address, we will make sure that we do. We will send out the slides and all of those things. But really quickly, if your employees file for unemployment during this time because of a reduction of pay or hours, or both potentially, will this impact our eligibility for the, and this is the Paycheck Protection Program loan, is specifically what this person is looking at, and or the forgiveness of the loan, and our thoughts. And I will first say, remember, once again, we are not tax or accountant advisors, but I would say, and I'll jump in and first just say, I do believe that it would have some impact on that. Yes, I think that the purpose of the CARES Act in general was designed and built to allow employers to keep their employees. So I think that there would be some components where that would be affected. And Kate, Jeannie, anything to add?
I would also agree, and the Treasury Department put out a wonderful 2-page, and I think we include that in our links, that kind of just talks about, what will impact the forgivability and the rehiring process should you have to, or you've had previously to lay some folks off, and then you want to recall them based on when your loan was originated and things around that piece. Again, not a tax advisor.
But yes.
Yeah, just I'll say ditto to what you said so far. That's my understanding of it. I do really think this is one for you to talk to, your accountant or tax advisor, or, even your bank as you're going through that process and applying, to kind of see what those, what if scenarios are and how that would impact.
Absolutely. Well, I want to say thank you. First, Jeannie, always thank you for being my partner in crime and doing this and engaging with these questions. Mike, thank you for the opportunity to have this platform to share that information. And especially a big thanks to Kate. I know that you are incredibly busy right now. I know this, and I'm so grateful to have you come and partake in our adventure here. I want to open the floor to anybody who wants to say a final thank you. Just as a quick note before I do that is, again, we are not attorneys or tax accountants. Please follow up with those people and your partners for your own organizations, and we will send out a survey link, as well as our slide deck and a copy of the recorded presentation. Anyone else would like to say thank you and goodbye? This is the time.
Yeah, Kate, thank you. I thoroughly enjoyed hearing you, and it was fascinating. I do believe Tilt would be an amazing product right now with these crazy times, so I'm excited to take a look at it.
Absolutely.
Thank you. I was just going to say thank you so much for having me. I really enjoy this as a HR nerd myself. I did go ahead and drop my email into the chat in case there's anybody on here that has a question. I'm happy to look into it or point you in the right direction. Or if you have questions about Tilt event, please feel free to reach out and consider us.
We'll be sure to include your contact information in what we send out. No problem.
Okay.
Mike, anything to add?
See you next week.
That sounds good. All right. Well, thank you very much. We appreciate your time and have a great rest of your week, everyone. Thank you.
Likewise, bye.